Hello, everyone, and welcome to our financial webcast presented by Legend Financial Advisors. I want to thank you for joining us for the webcast today. Today's webcast presenter is Jim Holtzman, CFP, CPA, CEO, and President with Legend Financial Advisors. Please hold as I turn it over to Jim.
Okay, well, thank you everybody for joining us. So this tax bill was passed right at the end of 2022. So there's a lot that goes into this tax bill. What I did was I tried to pick out the areas that would impact most people. There's beyond the presentation today, there's so much more that's part of this bill. So we're really just going to try to hit the areas that impact most people. So as always, we'll provide the replay, and you'll be able to have the slides, and that way you can focus on the presentation and you don't have to worry so much about taking notes. So what this bill is called, it's called the Setting Every Community Up for Retirement Enhancement Act. That's what the SECURE actually stands for. And this is SECURE Act 2.0, and that's because there was SECURE Act 1.0 passed in 2019. So there's actually, I think, reading through some of the reviews of this new bill, there's about 100 provisions that are actually in this bill. So just gives you an idea of the depth for it. In general, the impact is pretty positive. It's really about encouraging saving in retirement plans. That's kind of the general theme, adding different provisions which we'll get into that are more in a positive light. They're not taking anything away necessarily, but the main provisions are just to really encourage more savings, whether through the employer 401k plan, your IRA plan, and that's really at a high level what we're going to be getting into. So the next slide we're going to cover is going to be as far as the impact goes. So they're saying that these are the most expansive changes in the last 40 years. That was one of the summaries that came out of this, and it makes sense. You're going back into at this point the 1980s, even before 401k plans really came into being. So these are very big changes that they have put through over the last 3 years at this point. So the general theme again is that really getting individuals to save more for retirement, and it doesn't fit everybody's financial situation as far as what you can actually do or not do. So that's what we're going to go through. This is a big one. New rules for required minimum distributions. So for the longest time, a required minimum distribution started at age 70 and a half, and this is the rule where the IRS says it's time for us to collect our taxes. You've had money in a retirement plan for so long, tax deferred, it's time to collect. So what happens in these situations is that the IRS provides a table that you divide your account balance by. So the mechanics are you take the prior year-end balance of your retirement accounts, you divide it by a divisor that's basically based on life expectancy. And what that equals is what you're required to take out. So the way it works, it's about a 4% distribution in the first year, and then the percentage distribution goes up a little bit every year, and that way more money comes out over time. So the new rule back in 2019, as part of the SECURE Act 1.0, they moved the required minimum distribution beginning age to 72. From 70 and a half. Now, if you were already taking a required minimum distribution that started at age 70 and a half, you continue. There's no change for you. So the impact now is that it's changing once again. So the starting age for those that are born from 1951 to 1959, the starting age goes to age 73. And then for those that are born in 1960 and later, the RMD age is actually pushed back to age 75. So they're pretty significant changes just because one of the things we'll go through with our clients is in a period of time where if they're not working any longer and they're not taking a required minimum distribution, there's some planning opportunities you can do. Consider things like a Roth IRA conversion. That can be a very powerful move because a Roth IRA is not subject to the required minimum distribution. So it's a way you can kind of control the tax brackets and convert an amount that makes sense in that year. as opposed to the IRS coming up with this table that says how much you have to take out. So one thing that's also interesting is that they reduced the penalty whenever you miss a withdrawal. So it used to be 50%. That now goes to 25%, and they've added a 3-year look back for that purpose. And then if it's corrected in a timely fashion, then it'll be reduced to 10%. They haven't exactly defined what timely is, but basically if you correct it, it's going to be reduced unless it's a really long period of time. But there will be some clarification on some of these timing issues once they provide some additional guidance on that. Another area it's interesting, they've removed required minimum distributions for Roth 401k, Roth 403b, and Roth 457b accounts. So I just got done saying a Roth IRA does not have a required minimum distribution rule. However, Roth 401k, 403b, or 457b plan did have a required minimum distribution you had to take. So a common move would be to just simply transfer the funds in one of these accounts over to an IRA rollover account, and then you wouldn't have to take the required minimum distribution. It's kind of an odd rule. They have now eliminated that ruling, so all of the retirement plans are on the same playing field. So another change has occurred with the surviving spouse beneficiaries. So this has gone through a lot of changes already in the last couple of years. So there was a change that was made that what they called the stretch distribution, and that would be where a non-spouse beneficiary would receive an IRA account inherited from, say, one of the parents, and then they could take that distribution out over their lifetime, which was a pretty favorable outcome because when you base it on life expectancy, it would not be a very large distribution. Now there's a new rule that the money has to be taken out in 10 years. So there's a couple of exceptions to that, and they've added another one that'll be effective in 2024. So just to start with, surviving spouses can now adopt their deceased younger spouse's RMD age. So if you're a surviving spouse, the spouse that passed away was younger, you could inherit their schedule, which all things equal would be a lower required minimum distribution amount. So the options you had before 2024, are you could roll over the decedent's IRA or retirement plan to your own IRA. You could treat the decedent's IRA as their own, meaning the surviving spouses, or you could, and in those first two cases, you would have to take the distribution over your lifetime. So if that's the case, now that you can, as a surviving spouse, adopt the younger spouse's RMD schedule, this gives you a new option, which all things equal would have a lower required minimum distribution. So another area that's interesting is that if the surviving spouse dies before the required minimum distribution age is initiated, so the decedent spouse hadn't started their distribution yet, and then the surviving spouse dies before their required minimum distribution starts, then the beneficiaries are actually allowed to go back to the old stretch rule. So that's a big change because, again, for the surviving decedent, that required minimum distribution would be a lot lower as opposed to having to take the money out in 10 years, which is the way it applies for non-spouse beneficiaries with this exception. And I'll talk about a few other exceptions to that rule as well in one of our later slides. So this is a really big change just because of that. It seemed like, they basically took away the stretch rule as a way to generate more taxes, and now they've made a tweak to that already. So this was part of the Secure Act 1.0, and they removed age limits for contributing to an IRA. So the way it used to be is that if you're contributing to a traditional IRA, you couldn't do that past age 70 and a half. Now you still have to have earned income if you're past this age, but you don't have to stop at 70 and a half. You can contribute all the way into your 80s if you're working and have earned income, and you can continue to do so. Now we're going to talk about some changes in enhanced catch-up contributions for qualified plans. So the way it has generally worked, if you're age 50 and above and you had a 401k plan, 403b, 457 plan, you could make a catch-up contribution. So what is changing, and this will be for 2024 as well, is number one is that they are going to inflation adjust catch-up contributions, and this will also be for IRA accounts too. Before it would be set at different amounts and it wasn't necessarily based on inflation. This will happen automatically now. They would inflate it, and then when it got close, they would round it up to the nearest thousand. That's when it would change. But now this will change on an annual basis. So another change, this is not effective till 2025. This one applies for 401k and 403b plans. It didn't say it applied to a 457b, so we'll have to see if that gets added in. So they've enhanced the catch-up from ages 60 to 63 to be the greater of $11,000 or $10,000 or 150% of the catch-up contribution amount. So this is a big change. The catch-up contribution amount, for example, this year is $7,500. So it would be the greater of $10,000 or 150% of the $7,500, which is now $11,250. So they're going to inflate the $10,000 over time. They haven't said if they would adjust the $11,250 over time, but if the catch-up contribution is going up anyways, that other part of the equation will go up as well. Now, for a simple IRA plan, the catch-up again has changed for those age 60 to 63. It's the greater of $5,000 or 150% of the regular catch-up contribution amount. So you can kind of see some of the general themes. They're trying to encourage more folks to save for retirement because there's still a big problem with, in general, the studies say that there's a huge gap in terms of what investors or what individuals or families should have saved up for retirement. So another way to look at this as far as these enhanced catch-up contributions. So it's going to break down into 4 different age brackets. So up to age 49, there's no catch-up. So that's kind of, it's exactly the same as it used to be. So now age 50 to 59, you have what we'll call the standard catch-up. This year it is $7,500. Then you have the age 60 to 63 catch-up, which is the greater of $10,000 or $11,250, which is 150% of the standard catch-up, and that will start in 2024. And then it goes back from age 64 and above to the standard catch-up, which again this year is $7,500. So some part of their studies indicated this is really a sweet spot to try to really encourage potential, in upcoming retirees to really boost their retirement plan contributions. So now the part, kind of a second realm of the Secure Act is that they're providing more ways to save for retirement. So let's jump into that. So the Roth account, this is interesting. So previously, and this is effective this year if the employer has their documents to do this, the employers can now make an after-tax contribution to a Roth plan. So the way it worked previously would be the employer match would have to be, it would be a pre-tax deduction, and then when you take the money out in retirement, it would be fully taxable. Well, now employers have the option to do a Roth or what I'll call a non-Roth 401k matching contribution. It's pretty attractive because there's no income limits when you contribute to a 401k that has a Roth component, and now the employer match can go into the same account. So that's a big shift from what is used to have occurred because of the fact that the ages they're increasing the contribution limits. The after-tax component for the Roth IRA is going to be changing now, where that at least is an option. And it should provide really good opportunities for longer term planning because the withdrawals out of a Roth plan are going to be tax free. Now, the catch up for higher wage earners has to go to a Roth account. Now, what's a high wage earner for this purpose? It's considered 145,000 and above. So why would they do that? So basically, what the IRS is doing, or Congress, you could say, as far as passing this bill, is they want more money to come in tax-wise. So if you were putting money into from an employer standpoint or from a catch-up standpoint into an account where you could write that off, meaning pre-tax, now they're saying that for these particular wage earners, the catch-up contribution has to go to a Roth account because it is after tax. So it's an interesting twist that they've never really had in place before. And then the elimination of the RMD, the required minimum distribution for Roth accounts, again, that starts in 2024. So these are big changes that they put in place for this. Now, this is interesting too. Over the last probably 10 to 15 years, these different tax rules have been encouraging more folks to save at younger ages to help their longer term retirement situation. So with auto enrollment, there's been some changes that have occurred with that. So now, and this will start in 2025, companies are required to auto enroll employees into their 401k or 403b plan. Then in year one, meaning year one of the employee, the employer can defer or auto enroll you between 3 and 10% of your earnings. Now, as the employee, you're able to opt out and not have that occur. But the key thing is that the employer is doing this automatically. They pick which percentage, and then from the employee standpoint, they can make further changes, or even just say, I'm not going to contribute anything to the 401k or 403b plan. Then in years 2 and greater, the employer can actually select the deferral percentage as high as 15%. So again, the theory behind this is a new employee starts working, they haven't had a paycheck yet. If 5% of it's going into the 401k plan as an auto enrollment decision, then in theory the employee hasn't missed any money yet because they haven't started receiving money yet from the employer. And the studies have shown that it actually has made a big difference. And the 401k balances in general are going up, and they believe this is part of the reason why. Now, for 401k plans for small businesses, so the new law is going to be, and this starts next year, the small business can offer what's called a starter 401k plan. So they'll have the auto enrollment will be part of this. The opt-out will still be there for the employee, and then contributions to the plan are only made by the employee and are linked to the current IRA limitations. So you're still able to contribute to an IRA, but this at least gives another opportunity to have another retirement account that you can contribute to. So that's an interesting twist as well. So now 401k plans for part-time workers, the new law is that employers must allow part-time workers to contribute to a 401k plan. The employee must work at least 500 hours for 3 consecutive years, or 1,000 hours throughout the year. But this is a big change. This at least gives part-time workers the potential to contribute into the 401k plan. Now we're going to talk about SEP and Simple IRA plans. So previously, these type of retirement accounts had no Roth option. Well, that's now changing. So the new law, and this starts this year, is that a Roth portion or Roth feature is going to be available in the SEP IRA and Simple IRA plans. So this is a big change, because previously you just put the money into a SEP IRA or Simple IRA, you would get the tax write-off, and future earnings would be tax deferred. Then you pay taxes on that down the road when the money would be taken out. But now you can have a Roth option where you can put the money in after tax. You wouldn't get the tax write-off, but you would get all the benefits of the Roth IRA, which would be tax deferred growth, and then no taxes on withdrawal, provided you follow the minimum 5-year holding requirement, post age 59 and a half, just some of the normal rules that are part of the Roth IRA rules already. They also put in a provision where a SEP IRA can be added for household employees. With pardon me, in 2024, the simple IRA is going to get additional employer contributions. So that'll now be capped at $5,000 per participant. And then the simple IRA contribution limits will increase basically by inflation. And that also is new. So this is an interesting component as well. So it's framed as being for an employee to help build an emergency savings account. So this takes effect in 2024, and there's not a lot of detail out on this yet. But what the idea is that these emergency savings accounts are going to be offered with a qualified retirement plan. So think 401k, 403b plan. So the employees may auto-enroll in this. Highly compensated individuals are not eligible for it. And then qualified emergency withdrawals are capped at $1,000 per year, and you must repay the funds or wait 3 years to take another distribution. So I have a lot of questions on this part in terms of how it's going to operate, but this again is part of the theme of what they are trying to encourage: additional savings, additional money in retirement accounts. So this is a new one for student loans. So when an employer is, or whenever an employee is contributing towards their student loans, what happens is that the employer is now able to make a matching contribution to their retirement account. And so that applies for these retirement accounts. And then you can use those contributions for qualified student loan payments. So, and again, another way, student loans have become a big topic recently in terms of the balances students have when they graduate. So now we have more of a shift in the theme in terms of helping students with their student loans in a little bit of a different fashion. This is also a big change. So graduate and postdoc students now are able to contribute to an IRA. That actually wasn't the case before. They had a stipend or some kind of a payment arrangement. They couldn't make contributions to IRAs. So that's a big one. Excuse me. Now, if you have a 401k plan, the new rule is going to be that the statement has to show you an estimate of what your lifetime income would be. So you're basically converting the balance into your account into an income stream. So this is all the detail that they've provided so far. I have a lot of questions regarding the assumptions that'll go into this because I would assume it would be standard. And we'll have to get more details on that. But this will help employees to at least see the potential for how much income can be taken from the balance of the 401k plan. Just trying to provide more information, getting everybody to think more about retirement, converting that into a monthly income stream from the balance that has been built up over such a long period. So now we're going to move into our third main area. So the Secure Act provides new ways to use your money. So that's an interesting way to look at it. The first thing, and this is nice. So the qualified, QCD stands for Qualified Charitable Distribution. So what that is that it is a direct transfer of funds from an IRA to a qualifying charity, and that starts at your age 70 and a half. So what they're doing now is that it's been capped at $100,000. Starting next year, this limit is going to be indexed for inflation. That's a lot of money. I mean, to be able to gift to charity through this method. But their thinking is that this will help reduce taxes, because if you had let's say your required minimum distribution was $20,000 and you always give $5,000 to charity, as opposed to having the $20,000 be taxable, you could gift the $5,000 worth of contributions from the IRA, and then that would leave $15,000 that would be taxable. So this has been a really nice provision that was added a couple of years ago, and now they're enhancing it, although I haven't seen anybody actually gift $100,000 from the IRA account. But at least it shows the direction that they're heading in. And this is great because less folks are itemizing their deductions, and charitable contributions are part of the itemized deduction. And since the standard deduction has been boosted up so much, it's only like 8% of U.S. taxpayers are even itemizing now. So with the qualified charitable distribution, this is a way to get kind of a charitable benefit and lowering your taxes directly. So it's a great benefit if you have charitable intentions, you're post age 70 and a half. This is something that really makes sense to consider. Now we're going to talk about 529 plan accounts being used to pay off student loans. So this one has been in place for a couple of years. Just as a refresher on this, the investor can withdraw up to $10,000 from a 529 plan to repay student loans, and that would be done tax-free. So it's a nice benefit because previously you couldn't do that, and now you have a way to at least knock down your student loans. This is a lifetime limit. You can't do this every year, but it's nice that you can actually knock off the student loans this way. Other changes that came about, again, this was a couple of years ago. 529 plan monies can be used to fund apprenticeship programs as well. And then it was also increased, or at least in terms of the usage, to be able to cover K through 12 private education. So that, these are just enhancements they've been making to 529 plans over time. Now this one's a new role and just a whole new concept. So with the 529 plan, one of the concerns from a parent standpoint or grandparent standpoint on funding a 529 plan is that those funds are locked in for education purposes. So just to take a step back on 529 plans, you put money into a 529 plan. Basically, every state has at least one. You get a set of investment options to work from. The money grows tax deferred, and if it's pulled out for what they call qualified higher education expenses, that withdrawal is tax-free. But look, if you take money out for a non-qualified expense, you've got taxes and penalties to deal with. So the concern was always, well, I don't want to overfund the 529 plan. And there's a lot of ways to get around that. And you can change beneficiaries, and that's tax-free. Even the child can maintain it for their children down the road. So there's some really long-term planning involved with this. But what's interesting that they added in is that the new law is that parents can roll over up to $35,000 of 529 plan funds into that beneficiary's Roth IRA. So a little bit of the detail behind that is that the 529 plan must have been in effect for 15 years, and then the cap for the lifetime is $35,000, and then this also follows the annual IRA contribution limit, which right now is $6,500. And then the beneficiary still has to have earned income to be able to do this. So they put the 15 years in so somebody couldn't just make a play for getting money into a Roth IRA this way. The cap, they just set that as a cap. And then you can't do it all at once, but you would follow the annual IRA contribution limit. So that should resolve some of the angst or anxiety a parent might have on overfunding, because it can at least go to the child this way. The transfer would be tax-free to the Roth IRA, and then all the benefits of the Roth IRA would accrue. So very interesting change. So now another usage of retirement plan money is you can take a penalty-free withdrawal to fund long-term care insurance premiums. So this will be effective at the end of 2025. So what this is that the employee can withdraw $2,500 annually from their company retirement plan to pay for long-term care insurance. So they limit it. The way it's set up is that the withdrawal is allowed for the lesser of 10% of the amount that you paid for the long-term care insurance, or 10% of the vested balance in the plan, or $2,500 annually. So this is an interesting benefit. I mean, the cost of long-term care in general have really been increasing. As a result, long-term care insurance has been increasing, and this gives an opportunity to pay for it on a tax-free, or I shouldn't say tax-free, penalty-free basis. The thing about this is that you still have to pay the taxes on the say you took $2,500 out. This just eliminates the 10% early withdrawal penalty. So I'm not sure how popular this one will ultimately be, but again, they'll enhance this over time, is my suspicion, and maybe it'll get to a point where it is a tax-free withdrawal. But that's not the case right now, but they at least took a step in that direction. So this one's been in place. New parents may withdraw up to $5,000 from a retirement account for qualified birth or adoption expenses. And again, you don't have to pay the 10% penalty, but you do have to pay taxes. So the other nuance behind that is it must occur within 1 year of the birth or adoption. So again, they're just trying to give some ways to still encourage retirement plan contributions, because one of the things that can discourage that is knowing that if you need the funds down the road, you'll have to pay the penalty and pay the taxes, which you're always going to have to pay at some point. And now they at least give you more incentive to save up and be able to use the money and avoid the penalty. So a couple of other things they added in, penalty-free again withdrawals, is they've made new provisions that can be made for those that are terminally ill, victims of domestic abuse, and public safety workers. So they didn't indicate if there's any kind of a cap on this, so we'll get more clarification probably in the next month or two, I would anticipate. So now we're on to the fourth key. So we're going to talk about inheriting an IRA and some of these new rules with the stretch IRA, and talking about what the stretch IRA going away. So we'll dive into this a little bit more now. So the time limit for an inherited account, including Roth IRAs, is that, as I mentioned earlier, with certain exceptions, and I'll cover those, beneficiaries of IRAs must liquidate the account within 10 years. So you can do that. You can do it equally over 10 years. You can wait the 10 years and do it all at once. But then if you have an IRA account, you're still going to pay taxes on it. So the analysis you have to do, and what we help our clients think through on this, is looking at if a beneficiary, if they've inherited an account, should they take the money out every year, pay maybe a lower tax rate, or let the funds grow, compounded, tax deferred for 10 years, take it out all at once. It'll probably push you up maybe one or two tax brackets. And so you got to run the numbers on this to see if there's really a compelling reason to do one or the other. Sometimes there is. There can be a compelling reason maybe to let it grow for 10 years. Maybe you've inherited an IRA and you're still working and you're in the top tax bracket. So, that would be an example of that. So the same thing applies to Roth IRAs, meaning the money has to be out within 10 years, but you still don't pay taxes, which is one of the key features of a Roth IRA. So in that case, in most situations, it would make sense to let the Roth IRA grow for the 10 years unless there's some kind of a cash flow need that comes up. So the changes, again, were done in terms of eliminating the stretch IRA distribution over a lifetime in order to generate more taxes. Now, the exceptions I had mentioned that are for this 10-year rule of having to get the money out. So if you're a surviving spouse, you don't have to take the money out in 10 years. If you're disabled or chronically ill as the beneficiary, you don't have to take the money out in 10 years. If the beneficiary is not more than 10 years younger than the original owner, those stretch IRA distributions would still apply. And then if you are a minor child, you do not have to do the 10-year rule. You would be able to do the stretch rule. However, once you hit the age of majority, it switches over to the 10-year rule. So, in this kind of an example, you could have maybe additional 5 years, depending on the age, and then you have to get the money out in 10 years. So the big thing is that this only applies for accounts that were inherited in 2020 or later. So if you had inherited an IRA account 2019 or earlier, none of this applies to you as a non-spouse. You are able to take the distribution out over your lifetime and continue that calculation. So this has probably been the biggest area, as I was mentioning before. If you have a situation where, from a beneficiary standpoint, there's a lot of things to think about, but from the owner's standpoint before death, there's a lot to think about. So knowing that you say it's going to be your child or children are going to be inheriting an IRA and in this position where they have to take the money out in 10 years, depending on your situation, there's ways maybe you can pay lower taxes over time by doing some planning. One of those would be that Roth IRA conversion option, because maybe the owner, again, is in a situation where they've retired, their income has dropped, they're not taking any required minimum distributions yet due to their age, and converting money at a really low tax bracket could be an option. And so the benefits are for the owner is that they're doing this at a low tax rate. If they need the fund, then it'll be tax free down the road. And then if their children inherit the Roth IRA, yes, they got to get the money out in 10 years, but they won't pay taxes on it. So there's going to be more need for tax planning due to this because now it impacts not only the parent, it also impacts, you're also thinking about it from an inherited IRA standpoint, and it can make a big difference over time. So if there are distributions coming from a retirement account, just say the cash flow need is there, you aren't age 72, now 73, and you're taking money out of retirement accounts, then you also want to manage the tax brackets in that situation too. Maybe you're in the 12% bracket, and maybe it makes sense to take additional distributions up to the top of the 12% bracket as a way to lower required minimum distributions down the road, and then ultimately, again, maybe lower the overall taxable bill for an inherited IRA that your children might inherit. So it's all about tax bracket planning. This is huge right now. Reviewing your beneficiaries, making sure it's set up correctly, and just really thinking about all of this now more holistically, kind of multi-generational planning. That's always a part of retirement planning, but now with these new rules, it really changes how you have to think about it if you're trying to maximize your financial situation. So just kind of summarizing the key parts we went through. So the theory is that it's going to give you more time to save for retirement as far as what Secure Act 2.0 does. It gives you more ways to save for retirement, new ways to use your money in terms of taking money out and avoiding the tax penalty. And then you have all the issues surrounding the death of the stretch IRA and just doing really longer term planning around that, cash flow planning, Roth IRA conversion planning. So again, there's more to Secure Act 2.0. I just pulled out the parts that I thought were going to be most relevant most of the time. And they're pretty big changes on some of these. So if you need help going through this, we do go through with our clients a retirement plan review where we're looking at a projection, getting an idea of what your tax bracket's going to be in retirement. And it gives you an initial look to see if some of the planning opportunities I mentioned before make a lot of sense. Sometimes when I go through this with a client, it's really obvious that Roth conversion planning will make a lot of sense. But also, I run into other situations where things like a Roth IRA conversion don't make any sense. There's so many specifics that go into it, whether you have a pension, you'll have Social Security, if you have a lot of money in a taxable account, those things all can change some of the general recommendations for retirement planning. But it's something we're able to go through. We're able to lay out kind of year by year what's going to happen. And it's all projections, but at least it gives you something to start thinking about. And the closer you get to these various ages, the less the retirement projection is going to change. But it allows us to really get an early start with our clients and doing the planning and start to think about some of these solutions to some of the problems that come up, especially with the death of the stretch IRA. So with that, I will be happy to take questions. I can go back to slides if it's helpful and just see what questions come up now. So one question has to do with, in terms of tax planning, there have been a lot of changes made over the years. I'll talk about Medicare, for example. So with Medicare premiums for Medicare B and Medicare D, there are now income limits. So if your adjusted gross income basically is above certain amounts, you're going to pay higher Medicare B and Medicare D premiums. So if you are 65 and above and have Medicare, then you have to be really careful with some of the things that we're talking about, like doing a Roth conversion, maybe taking money out of the retirement account and paying the taxes on it because the tax brackets are such that it would make sense to do that. But you also have to be thinking about Medicare premium planning, if you want to call it that, because if you take too much out, then you might be bumping up your Medicare premium. Now, in the grand scheme of things, that could actually still be okay. It might be the right decision, but you want to be aware of that. So the way it works for the Medicare premiums is that if we're filing our 2022 returns now, the income reported on the 2022 return impacts the premium 2 years later. So there's a 2-year lag from when the year of the tax return, and the premium increase would occur if applicable. So there's so much to think about. I mean, you have you have to compare this to the required minimum distribution expectation. And if it's going to bump you 2 tax brackets, you might be better off paying more taxes now at a lower bracket and paying the higher premium. So there's just a lot of different nuances and different things you have to look at. Excuse me. All right. So another question is, can a Roth IRA be set up for part-time income earned after 75? And the answer is yes. Something that was interesting, even now that the traditional IRA has no age limit, the Roth IRA actually never had an age limit, so you could contribute post age 70. So certainly with all the rule changes that have come about, you are able to set up a Roth IRA for part-time income earned after 75. So you're able to contribute up to your earned income, the lesser of your earned income, or the contribution limit. So just a question about the qualified charitable distribution rules, and just kind of review that again. So when you reach age 70 and a half, and you don't have to be at required minimum distribution age, just age 70 and a half, that's where you can move funds directly to a charity from your IRA account, and you don't pay any taxes on that. So it could make sense at age 70 and a half to do this. You'd have to really look at the numbers on it, but certainly when you're required to take money out starting, say, at age 73, and I gave the example earlier, if your required minimum distribution was $20,000 and you already do $5,000 of gifting every year, then I can't think of a reason why you wouldn't take the $5,000 from the IRA and gift it directly to the charity. Because as opposed to paying taxes on $20,000, you would pay it on $15,000. And so to take that a step further from when I brought this up before, is now we're talking about all these different rules. You've got Medicare premium planning, you have tax bracket planning, those two being probably the two biggest things. So if you're able, any way you can reduce your adjusted gross income and your taxable income, you should take advantage of it, because you have all of these different rules that come into play. And this is a really nice one that completely avoids taxes. So if you're in the 22% tax bracket, that's a 22% benefit, if you will, or 22% of the amount you're contributing is a tax gift. So you're reducing your taxes by that much. So again, there could be situations where it doesn't make sense to do it, but for the most part, doing the qualified charitable distribution has been a really nice benefit, especially with less people itemizing their deductions and charitable contributions. They're still out there. You can still write those off, but you have to be itemizing. So a lot of times the standard deduction is used because it's the greater the standard deduction or the itemized deduction. And basically, most folks aren't getting over that amount of the standard deduction, and they have their charitable contributions, but it does them no good if they made them with after-tax money. All right, we'll wait to see if there are any other questions. Okay, looks like that's all the questions for now. But again, if you have questions on your situation, feel free to reach out. We can talk about some of the impacts more specifically to your situation, and really apply this, because it's a lot of different rules. Some of these rules won't apply to you, but some of them will. So with that, I'm going to turn it back over to Dan.
Great, thank you, Jim. A lot of great information and covering some of the recent updates. And I want to thank everybody for joining us for our webcast presentation today. If you'd like to schedule a free conference call consultation with a member of our advisory team, please call our office at 412-635-9210 to set up an appointment. Thank you again for attending, and this concludes the event.